Let's start with a basic principle of American law. What happens inside a jury room almost never sees the light of day. For centuries, deliberations have been sealed off, protected by a rule meant to preserve honest discussion and finality. Courts don't ask what jurors said. Lawyers rarely hear it. Defendants almost never do. But in 2017, a case out of Colorado forced the U.S. Supreme Court to confront a difficult question. What happens when jurors themselves report racial bias during deliberations? And should jury secrecy still stand when racism threatens the integrity of a verdict? You're watching the Truth Lab. Real cases, real consequences. And this is the case that changed how America looks at jury trials, and the case in Ohio that now depends on it. The story begins in Colorado. Miguel Pena-Rodriguez had been tried on misdemeanor charges. The evidence was contested, and the jury convicted him of the lesser offenses. But after the verdict, two jurors approached his defense lawyer. What they described shouldn't happen in any deliberation, and certainly not in a room deciding guilt. They said another juror, known as HC, made several statements tying his views of the case directly to Pena-Rodriguez's ethnicity. Comments like, "He's guilty because he's Mexican," and "Mexican men take whatever they want." They recalled HC dismissing an alibi witness by calling him an illegal, even though the witness was lawfully in the country. These weren't stray remarks. They were racial generalizations used to evaluate credibility and guilt. But here's the legal problem. Colorado, like most states, follows Rule 606B, known as the no impeachment rule. This rule prevents courts from considering juror testimony about what was said during deliberations. The idea is to encourage open discussion and protect verdicts from constant challenges. So when Pena-Rodriguez's attorney presented the affidavits, the trial judge didn't dispute the racism. He simply said, under the law, he wasn't allowed to consider it. And Colorado's appellate courts agreed. The evidence existed, but the law wouldn't let anyone look at it. When the case reached the U.S. Supreme Court, the justices confronted a direct conflict. Should deliberations stay sealed at all costs? Or does the Sixth Amendment, the right to an impartial jury, require an exception when racism is involved? Justice Kennedy, writing for the majority, described racial bias as a unique threat to the justice system, corrosive, dangerous, and fundamentally incompatible with a fair trial. So the court created a narrow but significant rule. If a juror makes a clear statement showing that racial animus was a significant factor in their vote, courts must consider that evidence, even if it comes from inside the jury room. It was the first time in American history that racial bias pierced the secrecy of deliberations. The impact didn't stay in Colorado. In Ohio, a man named Gregory McKnight had been on death row since 2002. His appeals had been rejected for nearly 20 years. But after Pena-Rodriguez, McKnight's defense team began contacting former jurors. Two came forward with accounts that echoed the Colorado case, racial statements reportedly made during deliberations. Before 2017, Ohio courts couldn't legally consider those statements. But now, the constitutional door was open. In 2021, an appellate court ruled that the trial judge used the wrong standard in rejecting McKnight's motion and ordered a hearing. For the first time in almost 2 decades, a court agreed the alleged racial bias needed to be examined, not ignored. So what does all of this mean? Pena-Rodriguez versus Colorado reshaped the balance between two key principles: protecting the privacy of deliberations and ensuring those deliberations are free from racial prejudice. The Supreme Court recognized that secrecy isn't worth preserving if it allows racism to shape a verdict. And it gave defendants, including McKnight, a legal pathway that didn't exist before. It also raises a larger question. If racial bias went unexamined in these cases, how many other verdicts might it have influenced? The jury room is supposed to be a place where facts guide the verdict. But Pena-Rodriguez reminds us that facts aren't always the only thing that enters that room. And when prejudice becomes part of the discussion, justice requires us to take a closer look, even behind doors that were once sealed shut. Because racial bias doesn't just affect verdicts, it affects trust, and trust is the foundation of the system. Sometimes, Justice means opening a door we were never supposed to look behind.